go on the record in the matter 23 CF99, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel, in person with Mr. English in custody. We're set today in this matter for a sentencing hearing after revocation. Mr. English pled guilty to receiving stolen property greater than $10,000, a Class G felony. He was put onto probation, in which he was given certain conditions to follow, 2 years of probation with a withheld sentence. He has been revoked off of probation, and he is currently now in front of the court for sentencing after revocation. The court has received and reviewed the Wisconsin Department of Corrections revocation packet and warrant and order request. I did not find anything from my perspective that jumped out to me as any type of material mistake for correction. The court also received, as part of that packet, the decision from the ALJ, the administrative law judge, in his revocation. Are we in victims' rights compliance?
Yes, Your Honor.
All right, thank you. Mr. Schmidt, argument and sentencing recommendation, please.
Before that, I did receive the packet. I reviewed it. I don't know if this is a correction, but page 2 of the DOC packet indicates where the dates they recommend to use for calculating jail credit. If you use those, you'll get 242 dates. Pages 28 through 29, however, list additional dates that also should be attributed that aren't in page 2. If you use those, the credit should be 262. So I agree with Mr. Chapman. It should be 262 if we include pages 28 and 29.
All right. Okay.
And that was the confusion where we were figuring out before court.
All right. Thank you. And so, Mr. Chapman, you agree with the 262?
Yes, specifically page 29, I think, was not included in the revocation order and warrant from the Division of Hearings and Appeals.
Okay. And you also confirmed with the either captain or lieutenant of the jail with regards to how many days he has since the packet or their calculation?
I did not. I know he's been in jail since May 27th of this year. My inclusion of, or my calculation of 262 days goes up until today.
Okay. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. Robert English was originally convicted in this case of receiving stolen property. The criminal complaint details that police found property burglarized from nearby places at his residence with his mother in Danbury. The implication in that case was that Kenneth Ochterling was somehow involved in the burglaries, and he was just receiving property he believed was stolen. This is a felony with a maximum penalty of 5 in, 5 out. His only other conviction in Wisconsin is a disorderly conduct in 2022. Minnesota seems to be where most of his convictions are, where most of his life has been. That's where I'm assuming that because that's where the bulk of his criminal history is. He does have multiple convictions there, a felony and misdemeanor for generally either possessing drugs or for lying to the police. He's been extradited from Wisconsin to Minnesota 5 times for either not coming to court in Minnesota or for probation violation warrants. In this case, about a year after being placed on probation, he absconded from probation and once again came in possession of stolen property at his mother's residence in Danbury. He did the exact same thing that the court placed him on probation for a year prior. Both cases are victim cases. Both hurt Burnett County itself. In this case, you could tell from the whole packet, because they send a lot more information now than they used to, that he admitted to the violation of the burglary in Minnesota. He contested other violations in Wisconsin. The ALJ ultimately decided they would only find that with whatever evidence was presented at that hearing, receiving stolen property, again, not burglary violations here in Wisconsin. If you're wondering why he likely admitted for the Minnesota one, that involved DNA evidence being found at the scene, so that made it a little different than the Wisconsin ones. The balance sheet shows that for the year he was on probation before absconding, it didn't appear he paid any restitution towards Department of Corrections. Therefore, the victim in 23 CF99 will have the burden after today to collect on a civil judgment.
And what was that amount? Oh, I have it right here. I believe it was $930.
Yes, if you scroll to the last page of the DLC packet, it was $930 for restitution. If you add in all the other costs, it's $1,541. And that's where I made the determination that nothing had been paid on it. Yeah. So at a probation revocation hearing such as this one, the court's supposed to do the sentence it would have done back at the time Mr. English was originally sentenced. However, it can also consider his behavior on probation that can modify what the sentence can do. So in other words, conduct on probation could result in a worse sentence based upon how probation went. Robert English is 40 years old, meaning he doesn't have a young developing brain, but he's also not in the age range where we'd say they're, aging out of crime. His history actually shows like a ratcheting up of crime as he's entered middle age. He has a past history of crimes. However, they're just drugs and lying to the police. They are not really for stealing. This was his first conviction for something like that. So this is obviously not a max 5 in, 5 out sentence. He doesn't have a history of criminal convictions related to stealing that would, I think, be necessary to justify that kind of sentence. DOC recommends a 1-year jail sentence, which he's like I'm bad at math, less than 2 weeks away from a time served sentence on. I don't think this is a 1-year jail sentence. I do think that if Mr. Robert came before the court in 2023 at the original sentencing and said, I don't want to do probation, I don't think I can do it, I think there's a chance the court might have done something like a 1-year probation sentence. I suspect the court might have required upfront restitution for that, but I don't know for certain. But instead, Mr. English convinced the court to give him a chance. And the court took a chance when it placed him on probation. It even gave him the ability to discharge early from probation if he paid the restitution off and had no violations, which I took to mean from the original sentence. The court, probably because of the lack of history of theft convictions, gave Mr. English a chance, wanted to believe in him that he'd want to make things whole, make amends. I think for that reason, the fact that Mr. English did not pay back restitution, he stopped reporting to probation. DOC, the way ALJs used to handle abscondings, they used to say that strikes to the heart of probation. You can't be on probation if you're not being monitored. You're just not getting punished then. And because according to the sentence after revocation packet, with the admission of the burglary in Minnesota, that's an escalation. And with the finding of the receiving stolen property is one of the other violations they found. And just the fact pattern. He got placed on probation for receiving stolen property, having stolen property at his mother's house in Danbury involved with Kenneth Ochterling. And the violations are the exact same behavior. It's really bad when a person placed on probation while they were supposed to be on probation absconds and then does the same thing. That, I think, escalates it beyond the 1-year sentence. It's still not, a max prison sentence. I do think that some prison is necessary here because of how bad probation went in this case. With the information of the progression of probation, I would recommend something more than 1-year county jail. I would recommend a half sentence of 5 years where the breakup would be 2 years initial confinement, 3 years extended supervision. So that would still be half the total exposure. And then it'd be weighted toward the ES, meaning he's doing less than half of the initial confinement he could do and a little more than half of the ES. Well, I mean, the court could do a lot more ES. I think that sentence is necessarily to not depreciate the seriousness of the offense and also the behavior on probation. I also think that such a sentence is necessary because it'd be a terrible message in terms of specific deterrence and general deterrence to the public if a person can, look at probation as just like a gamble. If I don't get caught and keep trucking forward with the same criminal behavior, then maybe I'll just avoid a jail sentence at all. And that shouldn't be how probation should be viewed. It's It's a privilege for a person to be placed on probation. It shouldn't be viewed as a gamble. It should be viewed as the court taking a chance because there's good belief that a person's going to correct their behavior. They're going to make amends to any victims. And when we don't see that happen, it needs to be viewed as aggravating. We need to take that into account in the total sentence. So that's what I'm asking the court to do. Thank you.
Thank you. Mr. Chapman?
Judge, I want to clarify one thing. There was no burglary in Minnesota. The state repeatedly referred to the burglary in Minnesota and said it was different because Mr. English's DNA was found, so that's why he admitted to it. It was also different in nothing was stolen. This was an abandoned building in Minnesota that Mr. English was squatting in for a period of time. He left things there, like I believe a candle and some plates and empty food cans, but there was nothing stolen from there, and no evidence indicated that anyone was living there or how long it had been, quote unquote, broken into. So yes, that was completely different than the other alleged burglaries, the ones that were not proven. And the state says, well, based on whatever evidence was presented, you can see what evidence was presented. It's all in the packet. It's the same reports the state is using for its criminal complaints, which I believe the court already dismissed once, and then it came back after an amendment. I would agree that the behavior appears similar to the original complaint in 23 CF 99 in the sense that he's still associating with Kenneth Achterling. That's his fiance's brother. Looks like in the original criminal complaint, I had nothing to do with that case. I've just read the complaint, but it looks like Kevin Achterling brought these UTVs around and Mr. English was riding on one and had the key in his pocket. Maybe the state thinks Mr. English stole them, but the plea was to possession of stolen property, and the indication in the complaint is that looks like Kenneth took it. Similar behavior in this case. It sure looks like Kenneth was taking stuff and stashing them at Mr. English's mother's house, because he also has connections to that residence, as you can clearly see in the packet. Mr. Achterling was the one who was over there fixing, I believe it was the, was it the well? I think it was the well that he was over there fixing for her, and he was using stolen parts to install a well. The ALJ did not find that Mr. English was involved in any of the burglaries, and he was revoked for absconding. Perfectly justifiable. He absconded. He was homeless for a very long time. Mr. Achterling tells me that the last stable residence he's had was with his father 7 years ago. He doesn't get along with his mother. He can't live with her. He stops by there occasionally, but he doesn't live with his mother. He's been using methamphetamine for a very long time. Homelessness is probably connected to that. I know the criminal history in Minnesota is all connected to that, but his criminal history in Wisconsin consists of this case, 2 UTVs that were stolen the night before, found at his residence, and now the fact that he's been revoked and charged with other stuff that is currently set for trial. Given the criminal history is all drug related, not in any way related to stolen property, finding 2 ATVs the next morning at his house, yes, it's a Class F felony because the ATVs were worth more than $10,000, but it could have also easily been operating a motor vehicle without owner's consent. I don't think this is an aggravated version of receiving stolen property, and I don't think it calls for prison. I wish there was an option to put him back on supervision. I agree with the state that probation was essentially a waste of time here. I think Mr. English tried, but he didn't have a house, he didn't have a job, and he was addicted to meth. Probation, I think, was likely doomed to fail from the start. But I don't think that's an aggravating circumstances that makes the sentence now call for prison. Yes, he will be released soon if the court follows the DOC recommendation, but that's because he's been in jail for a very long time without any release privileges and essentially sitting 100% of his time in the county jail. I think the DOC's recommendation is appropriate. I would ask the court to follow it.
All right, thank you. Mr. English, is there anything that you would like me to know? Do you want to make any kind of statement today? You do not have to, but it's your only opportunity.
I would just like to admit, like, yeah, I did a scoundrel, except I didn't have a phone all the time, so I couldn't call. And I don't have a driver's license or a car, so it'd be hard for me to get from Maplewood, Minnesota, all the way up here to check in. And when I did get out of jail last time, I called my PO up here and told her I will try to get up here. My hardest, we did have a vehicle, except it wasn't reliable. It needed a back bearing and the rear tire, and so it wasn't safe to drive up here. And I kept telling her that I'll keep trying to find a ride if I don't have people that I can rely on really for that stuff. I did try. I did try my hardest, and yes, I do suffer from mental disabilities that I do want to get fixed. I wish you guys had mental health stuff here to help me. And with that, I'll just let you guys know I did try my hardest. I did. Instead of not having, like, I did try to live with my mom. And last time I was up here, a dude pointed a gun at me and told me to leave my mom's house for good. And I was like, all right, whatever. I grabbed my dog and left.
Okay. So you're basically just giving me excuses as to why you couldn't get to probation?
No, I'm just,
That's accurate.
yeah, that's accurate.
Accurate.
Yeah.
Explanations.
Yeah. And I'm sorry for my behavior.
I hear excuses, not explanations. There's a difference.
Yeah.
Anything else you want me to know?
No, that's it, Your Honor.
I have reviewed the revocation order and warrant packet, and I've heard arguments from both attorneys, and now I've heard your statement, Mr. English, as to why you weren't able to, in your words, weren't able to go to probation, and you absconded for a period of a year. Mr. Schmidt alluded to, or he stated, the court probably at your sentencing.
Mhm.
And he was pretty much spot on, because I remember your sentencing very clearly.
Yep.
I remember when you were arrested on this or taken into custody with this matter very clearly. I remember having discussions with you very clearly in my brain, in what I remember about that date and time and around that circumstances, the circumstances of this case, as well as at the time of sentencing. I remember very clearly that you told me that you were in a better position and that you were going to remain sober. And that was what you were looking at. I remember very clearly, you told me at the time that you then you had become a father.
Miscarriage.
What?
She had a miscarriage.
She had a miscarriage,
Yeah.
but you were going
Yeah.
to be a father.
Yeah.
And you were changing your life around completely because of, not only because you were becoming a father, but you realized at that time you were done with this criminal life. I remember that very
Yeah.
clearly. Am I remembering incorrectly?
You remember that correctly.
I'm remembering all of it very correctly. And Mr. Schmidt, when he said the court probably, most likely the court did this, probably because of this, he wasn't even here.
Yeah.
He didn't even argue that sentencing. And I don't know, and I don't know, maybe he read a transcript, but he was spot on with guessing what the court probably was thinking at that time. And those were all the things that I was thinking at that time. Because quite honestly, at that time, based upon the history that was recited to me with regards to your criminal history from the state, even acknowledged by your attorney, Mr. McLaughlin, at the time, and by you at the time, because I had seen you for that disorderly conduct not too far in the past from this case. It was serious. You acknowledged and you admitted with those ATVs and having that property, which wasn't yours, and then telling the court that you were going to change your ways and change your life, and you wanted to make it whole with the owner of those ATVs.
Yeah. I still do.
I know you still do. And that's great, grand, and wonderful.
Yeah.
Okay, great, grand, and wonderful. But we're talking about August 7th, 2023. August 7th, 2023 is when I sentenced you
Yeah.
originally for this. And that's when you told me all of these grandiose ideas and thoughts that you were having about changing your life, getting back on track, and making the victim whole. Because I believe, if I'm recalling correctly, the court discussed, or we talked about how in Burnett County, this is what's happening, or this is something that happens. And you're saying yes, and you're nodding your head. Because that is what happens in Burnett County. We're a vacation spot where our population triples or quadruples in the summertime or in the nice vacation times. And then it goes back to our normal population in the cold times because people close up their cabins, they close up their things, and that's where they become a target. In sentencing, you've been here before in front of me, and now you're here again. You've been in Minnesota multiple times for other things, and you've been on probation. The court has to look at how serious is this, all right? It's serious in the fact that it has taken somebody's trust away. Granted, you weren't the one that went in and took the property or did the things. You had admitted to receiving that stolen property, and you had admitted in that complaint that most likely it's probably Mr. Achterling, or you mentioned Ken and those things, but you admitted to receiving those ATVs, either for converting them to your personal use or selling them for a financial gain or some other thing like that, or to give to somebody and, be a hero. And here's your UTV, I guess, not an ATV, a UTV. I have to look at you and your record, your criminal record. I have to look at you where you are today. I have to look at you and how you were on probation when I gave you that chance.
Yeah.
I said, here you go. Here it is on a silver platter for you to better yourself, to better your life, to be that person. And I understand, and I'm getting where you're probably saying with that miscarriage, that caused some issues emotionally for you and for your girlfriend, and then it caused you to spiral, and then yada yada yada. That's what I'm going to believe, and you're nodding your head up and down. You're saying yes, that is.
It was very devastating when I got out and she said she had miscarriage. It was very devastating for me.
And I understand that, Mr. English. I do. I also understand that there are many, many people that come in to this court. They sit in that chair. They're sitting in orange, and that they have been through the same or similar, that they have substance abuse issues and all of those things, and they don't turn to this type of crime. It's usually just the possession of methamphetamine or the other drug-related things. But yet this is something where you're taking from somebody else. Even if you're not the perpetrator who goes in and breaks into that building or shed or whatnot, takes those UTVs, you may not be that person, and that's not what you pled guilty to. That's not what you admitted to, but you admitted to receiving that property, knowing full well it was stolen. Full well it was stolen. And you wanted to convert that to whatever use you wanted to do. I have to look at needing to protect the public, and that is the community of Burnett as a whole. Here, there may be a single victim, correct. However, with looking at protecting the public, I have to look at deterrence, not only general deterrence of specific deterrence of deterring you from doing this again, because slap on the wrist. It has to be more than a slap on the wrist, apparently, for you to understand this is not something to engage in. This is not something that you can do. And general deterrence to deter others from doing the same thing. Because again, we are a tourist county. We are where people come to vacation. They come to have their great and joyful, wonderful life. They live on the lakes. They use our woods. They hunt, they fish, they hike, they swim, they boat, they do all of those things. They come here for solitude. They come here to feel stress-free and away from their other grind of wherever they live. And the general deterrence is a sense for general deterrence is to say, hey, they deserve to have that peace. They deserve to have that solitude to come here. They deserve to not have to worry about their property when they're not physically there, because they have worked blood, sweat, tears in order to pay for what they have here. If this continues and there's no deterrence, then Burnett County loses revenue. We don't have tourists. We don't have people that want to come in here, because if it's a scary place and all your stuff gets stolen and somebody else has it, again, even if you're not the one who physically went in and took that property, even if this property was something that was stolen from Minnesota or brought here or vice versa, people don't deserve to have that fear of not having their property. I'm looking at your probationary period, and yes, it is correct. For the most part, the court looks at what the court would have done or would have sentenced at the time of the original sentence. But I also do have to look at what you did on probation, which was nothing, not one thing. You absconded for a year or so. You didn't even pay $1 of restitution, not $1.
It's hard when you can't get a job.
Whose fault is that?
Mine, I tried, and I got a job at the end before I got arrested.
Great, grand, wonderful.
Yep.
Again, great, grand, and wonderful. Hard to get a job. But again, you were given an opportunity and you didn't just blow it. You blew it, you missiled it, you threw some bombs on it, you did all the stuff and you said, doesn't matter. Because even if you couldn't get a job, you still could report to probation. You could still work with your probation officer, and you didn't even do that. So I do think that here today, it is more serious than what it may appear to be. But it does appear to be serious anyway. The receiving of stolen property, that is serious. So I do believe that this is a prison sentence. I'm going to sentence you to 2 years of initial confinement with 2 years of extended supervision. While you're on extended supervision, you will absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug testing. You will do some type of thinking for a change or breaking barriers. You will have no contact with anyone on felony probation or felony extended supervision without your agent's approval. And yes, that does include your brother-in-law and your girlfriend and any other person without your agent's approval. Anyone on felony probation or extended supervision, and in particular those related to illegal substance use and or any type of burglary or receiving stolen property or theft, those types of things. Gainful employment. And I'm going to go back to that gainful employment. There's plenty of ways that you can get a job, because we have the Ruth House up in Superior. People go there all the time, multiple felonies, and they still find a job. They still work. They still work on their sobriety. They do that.
I was thinking about that while I was in here.
Well, now you have time to think, because the Ruth House can give you a job. It can help you find a job. And I have people who have not had jobs in over 15 years that go to the Ruth House, that they have a job and they say, Judge, I have a job. I'm paying my way. I have an apartment now. I am sober. I've been sober for 200 days. I'm doing this. There are options and there are alternatives than absconding and not doing what you are legally required to do. There are options. So after gainful employment, I said the regular drug testing. With regards to early release programming. You are eligible for early release programming for the substance abuse. I think you are beyond the age for the challenge incarceration. You must pay your restitution. That is part of your extended supervision. You must pay your restitution, and your restitution will be paid, must be paid by the end of your extended supervision. So $100 a month when you are released from custody. When you are in custody, I'm ordering that the court costs and fees and the restitution can be collected by the Department of Corrections at what they determine to be reasonable while you are in state prison, and that is a condition of your extended supervision. DOC shall collect your sums. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. We have your DNA. Anything that you fail to pay means that the court will enter a civil judgment against you because you're always going to owe it. Plus, I could issue a warrant and you could sit up to 6 months in jail. Very important that you pay and you pay timely. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman.
262 days credit, please.
Thank you. 262 days of jail credit. We are adjourned.
Welcome, Chuck.